Bob, let's move on to Goulding versus Friendship House. This is another workers' compensation case, and it deals with the amenability of an employee to get workers' compensation when the employee is involved in activities that take place, first of all, off the work grounds and are not necessarily related to the worker's specific duties at the place of employment. Can you talk a little bit about this?
In the context of workers' comp, if you're working and you're injured, it's compensable. And then there are issues where were you doing an employer's errand? Were you at lunch? There are also many different times when you are during your work day that you're on your own time, so to speak.
You're on a frolic of your own. I think that's the way they say in the case law.
And then there are also times when your employer may ask you to do something, attend a bowling event that's voluntary. Hey, we're having a bowling night, and you go, and typically you're not covered for something like that if it's voluntary. In this case, the employer said they were holding this, what's called a family fun day. So the claimant was employed by a nonprofit. She worked Monday through Friday as a chef or a cook, and her job duties were basically cooking meals for and teaching classes to the employer's clients. The employer decided to host a family fun day on a Saturday, which they planned to have as an annual event. And the idea was that it was going to be a fun day for the employer's clients and their families. So they told the employees, they asked them to volunteer. And at the same time, though, they did say it's completely voluntarily, and that there was no adverse consequence if you did not show up. Well, Goulding, who was, again, decided to show up and was going to be doing and asked to do essentially the exact same thing she does for her job on a Saturday. She was doing the cooking and teaching for the employer's clients, the exact same job. During the event, she stepped in a pothole and injured her ankle. At the workers' compensation court dismissed the claim, concluding that the family fun day was social or recreational event. The appellate division affirmed, and on appeal, the Supreme Court ruled that the claimant's injury was compensable. They rejected that it was a social or recreational activity and went further and said, even if it was, the claimant would satisfy the two-part statutory exemption by noting that her role at the event was the same as her normal job duties, and that she wouldn't have been asked to volunteer for the event but for her employment.
So it was
a regular
incident of employment, basically. I wonder if they had asked her to be an umpire in a baseball game that same day, whether or not she would have had a claim. I guess, look, if they want you to volunteer to show up and then they put you to work, I guess you're covered by workers' compensation, right?
Right. Yeah, and I think that that's a fair result that's reached in the case, based on the underlying purpose behind the workers' comp statute.